even some of the inequities derive from longstanding implicit gender biases. We're good? So I give you my favorite example of the icon, Justice RBG. And Justice Ruth Bader Ginsburg gave a speech in 2016 to some Georgetown law students. And she wanted to demonstrate what is implicit gender bias, because we had been making strides in terms of explicit gender bias, but we hadn't been making strides with implicit. So that unconscious, those unconscious biases that we have that we don't even realize we have. And so she gave this wonderful example, and I'm just going to quote from her speech. She said, discrimination didn't end with the explicit lines in the law. Some of it went underground, but a lot of it was not even conscious. This was the term unconscious bias. How do you get rid of that? And then she goes on to say that she's told many people the story about the symphony orchestra. Someone had the brilliant but simple idea to drop a curtain between people who were auditioning and those who were judging. And in the 70s, there really weren't women in the symphony orchestra, according to RBG. But when that drop curtain at the auditions was used, there was an overnight change. People who thought they could tell the difference between a woman playing an instrument and a man, whether it be the violin or anything else, turned out they were wrong. And we can't do that in every sphere of human activity. How good it would be if we could. That's Ruth talking. But she then says, and then instantly the New York Symphony Orchestra was diversified. And so it just shows how deeply that gender bias runs and how we really have to be thinking beyond just kind of that explicit bias and be thinking about the gender roles. So now I quote Gloria Steinem. Sorry, I'm quoting all the queens today. But she talks about gender roles being the deepest cause of violence on earth because they normalize violence, dominance, and submission. And that the cult of gender is the most difficult to challenge because it is just exaggerated versions of the earliest ways we may have been taught to see people as groups rather than unique individuals. Gender domination tends to be the very first way we learn it's okay. We learn it is okay for one group to eat, even though they don't cook or clean, for one group to be paid for working outside the home, even though the other group does the important work of raising children that is mysteriously called not working, and to ignore or consider inevitable the fact that females are the objects of most violence around the globe. And so the law is perfectly positioned to help remedy these deeply ingrained biases, and although has played a role in creating it, can now try to acknowledge that defect and move forward. And if we look at today's world, we see an amazing array of women represented in every major institution: the judicial branch, look in the audience, the executive branch, the legislative branch. And while representation in and of itself is not enough, we need to change the systems. It is the first step. It gives us a seat at the boardroom table. Now we need to have influence beyond the boardroom. Our voices need to count and be heard. And conferences like today are a great step in the right direction. So thank you for that.
Thank you, Professor. And finally, the last question for this panel, we do want to bring it back to the fact that we have a lot of judges and lawyers in the room. Certainly gender issues would have an ethical implication, especially for the judges that are in this room practicing, and for the attorneys as well. The judicial ethical rules that address bias are included in your materials. But while the rules exist, from a pragmatic point of view, I'd like to ask our two distinguished professors, do you believe that gender diversity on the bench impacts the public perception of judges and the litigant's sense of justice? And I am anticipating an affirmative answer. And if so, how so?
All right, so I'm going to see what we are. Yeah, the answer is yes, absolutely. I think we can never underestimate the power of what litigants see as fair when they see the person in the black robe that looks like them, right? So representation is really that first step. And in the materials, I wrote an article about this, I think Narina put in here. A lot of judges talk about how does this diversity on the bench, how do those lived experiences of our judges affect not only our decisions, but also what litigants perceive as procedural justice, perceive as fairness. Justice Graffio, who was a many of you know, former judge on the New York State Court of Appeals, stated, "I think many people underestimate to what extent people bring their personal philosophy and life experiences to cases. And I think that's true whether you're on the trial bench or appellate bench. Judges are still people. They have their own value systems. They have their own professional experiences. They have their own life experiences. That's the lens through which they examine the facts in a case. So when you have people of different economic backgrounds, different ethnic backgrounds, racial, gender, that brings a different richness to the discussion." Also, many would say that if you have a more diverse judiciary, there are benefits to having a comparative, multifaceted understanding of the law instead of a uniform understanding of the law. At the trial level, diversity on the bench can be meaningful from a symbolic place for litigants. Again, seeing that person at the bench that looks like you or someone looks like someone in your family. But there's also a substantive place for the litigants and the public in the courtroom. And academics have written about the value at the appellate level, where there's already a process of group decision-making, but perhaps with so many folks making that decision jointly, we decrease the implicit biases that would otherwise come in. Judges exchange ideas on and off the bench. A judiciary that is comprised of judges from different backgrounds and experiences leads to an interplay and exchange of divergent viewpoints, which in turn prevents bias and leads to better, more informed decision-making. Diversity of opinion among decision makers encourages debate and reflection and fosters a deliberative process that leads to an end product that is greater than the sum of the parts. So certainly the answer is yes. In the final analysis, a judiciary that is comprised of judges from different backgrounds brings a fairer process to the table. And so in that regard, we have made a tremendous amount of progress in embracing equity in the courtroom.
All right. I want to thank our panelists. Did you want to add something else?
Add one more.
Okay, great. Yeah, thank you.
Okay, it was truly a short point. I wanted to add on to what Melissa was saying. So, right, thinking about agreeing, right, that representation matters. People are bringing their lived experience. And then I also want to add, as a continuation of what I was talking about, the power of organizations outside of the law partnering with the law. And so what I'm thinking about in this case, for example, is as you have folks who are normally excluded, right, women, trans, people of color, et cetera, ascending into these higher ranks, they bring a lived experience, but they also may make sentencing decisions that are not necessarily like pro-women, right, pro-trans, all of that. And I think part of that has to do with the existing bias that's in the law, right, and the existing things that are hard to buck, even if your individual identity is different. So I would just pitch again, that is also important for organizations like the one I was mentioning, the Domestic Workers Organization. Their push is what made the domestic worker bill happen, right, with all the protections that it brought. So I think similarly, it's hard when you ascend, right, as a minoritized, marginalized person up the ranks. It also can be isolating and difficult. And I think that outside groups and other support systems can help judges, lawmakers, et cetera, make decisions that are actually just, right? Pass laws that are just, equitable, supporting women, supporting care, supporting trans folks, not just about their own ascension, right? Because I think there's, again, it's difficult and there's multiple factors that affect how someone rules in this case, right? Or how someone, what kind of laws that they pass. So yeah, just want to end that. So representation, justice, and then partnering with other societal groups, I think is important for law. Thank you.
All right. Thanks and welcome back. I'd like to give out the one attendee that we have appearing on Zoom, her CLE code, which is bias. The CLE code, the first one is bias. So I'm joined this morning for a second panel by 3 distinguished jurors and trailblazers in their fields. They will help us understand not only their experience ascending to the bench, but what they see in their courtrooms daily with regards to gender bias, and not only. I'm going to give, again, some highlights on their bios. Judge Clark attended Columbia University and Albany Law School, during which time she also completed an internship with the U.S. Attorney's Office. After graduation, she went to work at Dreyer Boyajian as an associate. Shortly after, she was offered a position by Schenectady County District Attorney's Office, Robert M. Carney. At the Schenectady County DA's office, Judge Clark began as the DWI prosecutor and then moved to the General Felony Bureau. She became the sex crimes child abuse prosecutor and was then promoted to become the first bureau chief of the Special Victims Unit. In that role, she helped establish Schenectady County's Child Advocacy Center. In 2004, Mayor Brian U. Stratton appointed Judge Clark to the position of Schenectady City Court Judge, and she then won election to that position for a full 10-year term. In November 2010, Judge Clark was elected as Schenectady County Family Court Judge. In November 2012, she was elected to the Supreme Court for the 4th Judicial District of New York. And Judge Clark was the second woman ever elected as a Supreme Court Justice in that district, and the first Democrat to win election without a second party line. In April 2014, Governor Andrew Cuomo appointed Judge Clark to the Appellate Division, 3rd Department. She's married and has 2 daughters, ages 19 and 15. Hope that's still accurate. Judge Teneka E. Frost was appointed on January 2nd, 2018 by Mayor Gary McCarthy as Schenectady City Court Judge. She was then elected to a 10-year term later that year. She's the first African-American to hold this position. Prior to her appointment, she served as Chief Administrative Law Judge at the New York Department of State. Judge Frost is a 1998 graduate of Syracuse University, where she received a Bachelor of Arts in Political Science and African-American Studies. After graduating from college, she completed a dual degree program at Albany Law School and SUNY Albany's Rockefeller College of Public Affairs and Policy, where she received a Juris Doctor and Masters of Public Administration in 2002. I just want to say I went out of order. Judge, I'm sure you know, but for people who don't, Judge Frost began practicing law with the firm of Lemery Gracer LLC. She then held various legal policy and management positions with the Legal Aid Society of Northeastern New York, Albany Law School, New York State Department of Civil Service, and New York Department of State. Judge Frost has demonstrated a commitment to the legal profession, specifically to improving the lives of women and people of different racial, ethnic, religious, and other backgrounds as a lawyer, education advocate, and community leader. She's a member of the Capital District Black and Hispanic Bar Association, president from 2011 to 2012, the Schenectady County Bar Association, the Capital District Women's Bar Association, Alpha Kappa Alpha Sorority, local president 2011 to 2012, and the Albany District Chapter of Lynx. She currently serves as the vice president for the National Association of Women Judges, the New York chapter. In 2021, Judge Frost was appointed co-chair of the Equal Justice in the Courts Initiative for the 4th Judicial District and implemented the UCAN program, which is a court-monitored mentoring program targeting 18 to 25-year-old offenders, designed to give them an opportunity to take responsibility for their action without having a criminal record. Last but certainly not least, Judge Sherri Brooks-Morton is a lifelong resident of the city of Albany and a 2003 graduate of Albany Law School. She started her legal career as a solo practitioner, where she realized that she was living in a community that needed a strong legal ally. She became an Albany County Assistant Public Defender in 2007, where she handled thousands of cases before being appointed to head the Albany County Alternate Public Defenders in 2012. After a highly contested election in 2019, there were 7 people running. She took the Albany County Family Court bench in January 2020 as the first Black woman to sit there. She's also the presiding judge of the Albany County Court's youth part and acting Supreme Court Justice in the state's 3rd Judicial District. She's also a wife, a mom of 6. I'm going to say that again, a mom of 6, and anxiously awaiting her first grandchild in May. So, a very impressive panelists. Could each of you please give us a brief understanding of your experience ascending to the bench, and how has gender and or race played a role in that journey? And you can use the mics on the table if you wish.
Well, the 3 of us agreed we were just going to sit, so hopefully that's okay. I think that my gender was a positive in all of my races, actually. I was appointed to city court judge because there had always been a woman city court judge for a very long time. I was the third ever. The problem became after I left to go to family court, there was a huge gap of 8 years. So there was, I think, 4 white male judges appointed between me and Judge Frost. I then went on to family court. And after just 2 years, I decided to run for Supreme Court. There were 4 seats, only 1 incumbent. Judge Seiss is here today. So there was 4 open seats in this very large judicial district, the 4th Judicial District. It's 11 counties. It's from Schenectady to the Canadian border, all the way to the St. Lawrence River, all the way to Vermont. It's almost the size of the state of Connecticut. There was only 1 female judge in that district. And I decided to run because there were white men running on the Republican line, and it looked like there were going to be 4 white men running on the Democratic line. And I just kind of went to the party leaders and said, where are the women? And their comment was, go ahead, you want to go, run. You want to run. And basically said, you're not going to win. And I said, well, you're right, I might not win. But as I call it, the stars aligned. It was 2012, it was a presidential year. Senator Gillibrand was running for office. We had a progressive Democratic congressman in the North Country, Bill Owens. It looked like the North Country was tending more purple at the time. That's changed or shifted. So I was very lucky, I think. And I was the 2nd woman ever made it to the bench in the 4th Judicial District. So that happened in 2012. There have only been 1 before me. Now I can say, and there's a few of them here today, that there are 5 elected Supreme Court justices that are women, 5 out, I think it's out of 13. And there is also 1 appointed from the Court of Claims. So I think that we've come a long way. I'm the first woman ever out of the 4th Judicial District to make it to the Appellate Division. And at the Appellate Division, when I got there, I was one of 4 women. There's only ever been 9, right? And 9 out of 100. And although the first one was in 1977, there was very long gaps between those. And currently there are 5 women on the Appellate Division, 5 out of 10. So we're at equality, but we've never been the majority. So my hope one day is that we at least see that. So I do think that it was a positive. I can also give you negative stories about, seeking the Saratoga County Democratic nomination, and the men had spoken first, and then I got up to speak, and a very progressive left-leaning man in the back of the room stood up and said, I don't understand how you're going to do this if you have 2 small children at home. And the women in the room started yelling at him and really came to my defense. And he was a very progressive man. And I just stood there and said, well, you know what? I'm really lucky, right? I have resources. I have a nanny. I have, husband, and I hopefully have people that will continue to help me get elected, even though I have young children at home. And one of the other judges, he has young children at home. So why don't you ask him about how he's going to do it? So you did see those kind of roadblocks. I'll turn it over to you.
So as Norina said, I do have 6 children. I think that I'm in family court. So the expectation was a mom of 6, right, is appropriate for family court, but you don't want to be appropriate for family court because you're a mom of 6. You want to be appropriate for family court because you were a great attorney and you were smart and you have all the merit as anybody else. So, obviously I wasn't going to not use that to my advantage. So I checked all those kids up. But, I didn't want to think I was qualified as anyone else, even though I was appropriate also because I was a mom of 6. But I think it does make a huge difference because in my court, I'm the trier of fact. So there's no jury. You can't blame it on 12 other people. I have to listen to all the evidence, all of the testimony and make the decision. And I think it is absolutely true that you bring everything that you've experienced in your life professionally and personally, and you take that lens and you look at what you've heard. So it's very, very important to have somebody who, I grew up in Arbor Hill, I went to public school, I am a mom, and it's, my perspective is very different from a lot of women on the bench, because I found a lot of women on the bench were older than me, many had, you know, one child, no children, couple of children. So I had all of these things that were so different. And even when I talk to my colleagues, when we sit in a room, I think it's really, really beneficial to say, well, that's not necessarily the case when you are balancing. You know, I have people who come in and they say things like, this child shouldn't sleep on the couch. I'm like, my kids have bedrooms and they love the couch. I think it's just something you don't think about if you don't have that perspective. So it's like, well, that's not really that wrong, is it? And you, sometimes you think, you know, if people say they get McDonald's once a week, and I'm like, just what? So I think it's really, really helpful to have somebody who can come in and bring all of these different perspectives, and it does make a huge difference.
Good morning, everyone. I definitely want to echo what both Judge Brooks-Morton and Judge Clark state.
Sorry, my daughter always here.
Okay.
Am I wrong?
Oh, they're here now. And I'm gonna call her Sherri because we go back to high school. And we grew up in the same area, so I've known her for so long. And it's just an honor to share the stage of both of them. So I kind of broke it up into two, kind of like positive and negative, like you did, Judge Clark. And of course, you know, when you bring yourself to the bench, particularly when there has been a lack of diversity, so the same sort of individuals keep getting appointed, elected, that is obviously a positive and something that you do bring a different perspective. But for me, the negative is always, am I qualified? So no matter how, you know, I graduated from Albany Law School 20 years ago. I've been practicing law for 20 years, and I also been on the bench for 5 years. And I recently ran an election, and you know, people would come up to me and, oh, that's great. But you know, the question, you know, I would get that I saw that my colleagues, male colleagues, did not get was, oh, what are the qualifications for being a judge? And I'm like, I think I have to pass that because I'm a sitting judge right now. So I obviously have met the qualifications, but it definitely was a stark difference. And I asked my other male colleagues, I'm like, did you get this question? They're looking at me like I'm crazy. They're like, no, I've never gotten that question before. And so it is a, and I think that's a combination. We talked about, well, the professors talked about that intersectionality, and particularly with Black women, being that we are a person of color, being our gender. And I know for Sherri and I, our age, now we have some experience and life experience, and we won't tell you our ages, but we're not 20 in our 20s anymore, or our 30s. So. But, you know, we appear to be young. So I think that also goes into, you know, sort of this question that I have gotten recently, you know, in terms of being qualified. But it's definitely not fair. And it's something that I hope one day that people after me will not have to face that question. But I do feel particularly, and one of the articles that is your materials definitely spoke to this. For me, because of my experience, that feeling of being invisible and marginalized is something I bring to the bench. And I know what that feels like to have people make decisions about you, about your life, and you feel like, you know, you're not seen, or you're not heard, or you're not, you can't play a part in that decision being made. And so one of the things I definitely pay attention to is I'm looking at individuals and seeing, I want to make sure that they might not agree with what I decided, but do they feel like they've been heard? Do they feel like they've been respected? Do they feel like they have had the opportunity to have their day in court? And that's a visual thing that I look for, because you can tell when someone is confused. You can tell when someone has a question, and like, and I never want anyone to leave my courtroom with that kind of confused look on their face, because I know what that personally feels like. So that's something from my experience, being a person of color, being a woman, that I definitely make sure that I address from my perspective.
Thank you, judges. So we're gonna switch a little bit from your experience with gender and racial disparity to what you are seeing in the courtroom, and whether you are seeing that gender or racial disparity as it applies to male, female attorneys, judges, staff, or the people that you see before you in the courts.
So I try to think of an example, and just sort of from a general perspective. And for me, what I've seen is, I'm gonna speak about Black women. So particularly when I'm in the small claims part, where there's litigants who are representing themselves and don't necessarily have an attorney, and some of them want to come in and play attorney, right? They've done their research and they come in and they're like ready to like present all this irrelevant information. Like, I don't need that, but so one of the things that I've seen and heard people comment on, particularly for Black women, is that person has an attitude. The woman is there and she is advocating for herself, and she's, she's animated, she's passionate, and it's perceived as negative. And I will tell people, it's like, no, she's very passionate about what she's saying, just because she might be louder than the average person would be, or than you would be, I would say, or she is, flailing her arms, or, really, emotionally involved in it. You should not perceive that as something that is a negative, and you have to listen to what that person is saying and not bring your own bias into judging that individual who's trying to, this is people coming to court and they have very important things that they want you to make decisions on. And we have to respect that as judges. And we also need to not put our own thoughts and opinions about how a person should be presenting themselves. And so I think issues like that, where we are, and I'm speaking from the position of a judge at this particular time, where we see things that are different from what we may be used to, is that we should not place judgment on that, but really do our jobs to kind of learn about some of the different cultural differences and ethnic differences that people bring to the table. But also, making sure that we are not placing any negativity about how that person is presenting themselves. So that was just one example I came up with.
I have to second that, because I'm in a court where I see a lot of Black single mothers who come in and they're frustrated, and they have children with people who are hardly involved, and they want things to happen that, I have a lot of people come in and say, I want you to make him see them. And it's like, I can't make him see the children that he doesn't want to see, unfortunately. And they're very upset. And I've had people in my courtroom say, you're so nice, and you let them, and I said, it's not, it's just that people come to court and they want to feel like this is the time where everything that I've been trying to get off my chest this is my time to say it. So I just let them get it out. And then it's like, well, I'm sorry, I know you're frustrated, but there's very little that I can do about that circumstance. But they feel a little bit better, because they feel like, I've waited so long to be here. He heard me, the judge heard me, the attorneys heard me, and it is what it is. But you just have to say, they're not screaming and cursing because it's you. It's just this life frustration. I think Black women historically have had to advocate for themselves a lot more than any other group, because we feel like we're not listened to. And so we have this And as women in general, you don't want to show a lot of emotion because then you're, you know, you're this, or if you're a Black woman and you're angry. So it's like you teeter this line where it's like, I want to be heard, I want to advocate for myself, but I don't want to do it in a way that's going to reflect negatively. And so you just have to peel away all those layers of anger and frustration that they're trying to get out and say, this is what they're saying, this is what they've been through, and I hear you, and I'm sorry, but you know, this is the circumstance, and I see it every single day, and it like breaks my heart.
I think my experience now is very different than the experience that both of them are having. I mean, I sat in family court and city court and had those experiences. But at the appellate level, you know, we're reading a transcript, we're combing through, you know, the legislation. There are times that I can tell you, I have no idea what race the people are that I'm reading about. Sometimes you can make some assumptions about names, etc. But I think, you know, the appellate court, I think it's been important that we've all been trained on implicit bias and we check our biases, but you know, we have group decision making, which I think can make for a better outcome at times, because I think we all come from varied backgrounds, right? Our genders are different, our ethnicity is different, our economic backgrounds have been different, our sexuality can be different. And those things together, I think when we sit and discuss those things, we can call each other out. And we do and have called out the judges that are not being particularly kind, right? And have done some inappropriate things. You know, we've had to say to certain judges, you know, that was a racist comment, right? We've had to call those things out. And I think it's important that we do on the appellate level. And I think some of the biggest mistakes that we see are sometimes, you know, exactly what they were talking about is when judges are not being mindful and thoughtful and kind to the people in front of them. I mean, I know that might sound incredibly simplistic, but if judges, and I know they're incredibly overwhelmed at the trial level at times, but if they are doing what you know, Judge Brooks-Morton and Judge Frost talk about is taking the time to listen and to just be respectful back to the people and not put your own kind of moral value on them as they're telling you and why they're there. I think for the trial judges, it would make a much easier situation for us, the appellate level. But I have to say, you know, I'm really proud to be part of the third department, you know, run by our wonderful PJ, because I think we talk a lot about our, you know, I know with my own court attorney, who my current court attorney is a young man. He's Latino. He identifies as gay, and we have completely different backgrounds and come to the table, and I love it, right? Because his thoughts, sometimes, you know, we get to the same point legally, but his thought process will be like, oh, can you believe that person would? And I was like, oh, that's a different lens. So it's really important that we have those discussions and have those discussions with our court attorneys and have those discussions with other judges.
Well, thank you, judges. I think we've touched on this question a little bit, and Judge Frost, you did mention there is a very interesting article in the materials that does talk about intersectionality of gender and race. I just wanted to see if there's anything you wanted to add before I move on to the next question regarding other types of inequities that you might be seeing, like economics, education, any other intersectionality, maybe like sexual orientation, maybe identification.
Yes, there's definitely, as one of the professors stated earlier, there is I guess more awareness of people and how they identify from a gender perspective, particularly. And there is, I had one particular case where an individual came to court appearing as one gender, and when a trial showed up, he was a different gender. And it presented a real conundrum for me, particularly because the district attorney said that the person was in disguise and is trying to trick the court in terms of being someone else. And so these are issues and that are very prevalent that we have to grapple with. We have to make sure we're getting the proper training and understanding to be able to deal with the issues. But it is that I would say is probably one of the most challenging areas that I'm seeing, and it's continuing to grow because there's different terms that are being used. There's different perspectives, and it really is for me personally, I'm going to speak personally for myself. It's a complete shift from what I was taught and thought of. And it's a challenge to be able to understand it so that you're being respectful from the bench. It takes new techniques and new thought process to be able to understand the issues and to be effective in being a judge. And I'm thankful for the materials and the things that we do have for judges, but there's still a lot more that we need to learn and actually practice in the area when it deals to LGBTQ and also transgender issues.
Oh, yeah, absolutely.
I just want to talk about the economic disparity, which, you know, they can both talk to about at the trial level. But I think one of the things that needs to be thought about, and, you know, I know that the legislature is trying to address this in some ways, but, you know, access to justice, right? The funding things like the Legal Aid Society and the Legal Project, as well as just our 18B attorneys and our attorneys for children, right? If low income and indigent people don't have good counsel, I know we all talk about adequate representation, but really it's supposed to be meaningful, and we need to be able to recruit and retain good attorneys for low income and indigent people. So I think that economic disparity is huge.
And I was just gonna say, to follow up on that, we actually, my law clerk and I mean, I was a public defender and then the conflict defender for many, many years. So I spent most of my career being in indigent defense. So I actually, when I had cases and I had a neglect case, and it was very concerning because I didn't think the attorney was doing what they needed to do for this particular litigant. And I was really worried about the outcome because of this attorney's representation. So we actually removed that attorney and gave this person a different attorney because it was just an unacceptable way to handle a case. And I, never going to allow a litigant to not have justice because their attorney is too busy or too whatever the case is. So.
Yeah, and I think that's an excellent point. Thank you for bringing that up. Judge Frost, I know I'm kind of picking on you. I know you're very active in equal justice in the courts committee and have implemented numerous practices and programs to address the gender, race, and other disparities that you're seeing in the courtroom. And I have seen you speak about them before, so I'd like to have you address this audience and tell us a little bit about what you've been able to accomplish.
Thank you. Well, first I have to get a shout out to my co-chair who happens to be sitting, where is she? Sitting in the audience today. That is Acting Supreme Court Justice Kate Hogan. Would you please just raise your hand and let everybody know that? So she's my co-chair on the 4th Judicial District with the Equal Justice in the Courts Initiative. And we are so honored to be in a position where we are able to bring forth some awareness and issues about how do we create more equity. It's designed for the whole entire New York State, but particularly for the 4th Judicial District. And we often partner with the 3rd Judicial District as well. And so we just finished a wonderful event on February 10th. And it's our inaugural Solomon Northrop ceremony where we give out an award. We gave out an award to Judge Mendelson, who is the district administrative judge for the Office for Judicial Initiatives. I think I messed up her title, but most of you know who she is, and she does a wonderful work with regard to equal justice in the courts and access to justice as well. And so we presented her with an award, but really the ceremony talks about some history that we have here in our area where most of you have probably watched the movie 12 Years a Slave. That's a movie that's based upon Solomon Northrop's life, where he was a free person living in Saratoga County, Saratoga Springs, and was abducted and forced into slavery in the South. And his childhood friend, Henry B. Northup, who was an attorney in Warren County, actually represented him in court and won his freedom. So the ceremony is in light of that wonderful history, unfortunate, but wonderful history that we have. And we wanted to bring highlight to that. So the Equal Justice in the Courts initiative, we have worked on several initiatives to both bring equity awareness. So the committee is formed out of the J. Johnson report, which is a report that is online on OCA website from 2020 that talked about and really brought to light still a lot of work we have to do in terms of creating equity is from the perspective of racial bias, but obviously we know intersectionality, it's all related. And so we are working on things in terms of language access and making sure forms are one particular form, that public defender form in Amsterdam, where a huge population of individuals speak Spanish. That form was translated into Spanish and is available throughout the state. We held a summit last year with the 3rd and 4th Judicial District judges and talking about issues of race and then our experiences as judges and what are we're seeing. It was an initial discussion that we definitely need to follow up with, but for the first time there was a room full of judges just talking about issues about how we can better address the issues that we are seeing, and also what can we do ourselves to be more aware of the issues in terms of equity and access to justice. We are working on making sure that when people come into that courtroom that they feel welcome. And there's a mural being developed that will be representative of the different cultures and ethnicities in our state. And it will, the plan is for it to travel to different courthouses to be a representation of what we believe should be, not only a promise and a dream, but actual reality. We worked on reviewing some policies and procedures, where one particularly the sexual harassment policy, it was just recently updated by the Office of Court Administration, but we had a committee that sort of looked at it to make sure that the process could be improved in terms of making people feel respected during that process and also understand the outcome of any investigation. So, and more importantly, I think the most important thing, everything we do is important, but I do like working on the help centers, which is more of an access to justice type initiative. And that is where we are, for people who are unrepresented, giving them resources within the courthouses so that they can file papers in the areas of consumer protection, landlord-tenant law, and family matters. So those are some of the things that we're working on. We're just getting started. I know we're nice and hot right now, so we want to keep it moving, and we look forward to partnering with the other attorneys, the other judges, and really moving forward with making sure we address the important issues that were outlined in the J. Johnson report, and that we know there's things that we need to work on and continue to do to improve our court.
And thank you for all the work that you do on that committee. And I know those are just the beginning, but those are very important achievements that you've already accomplished. And interestingly, there was another report that just came out this week that speaks to gender in the courtroom. And I haven't read it all, I have to admit, but I'm interested to reading that and perhaps working with the gender fairness committees to implement some of their suggestions. And lastly, we do want to finish on a positive note. This is for all of our panelists. How do you envision embracing equity in the courts, and what programs do you think could help in that respect?
So, as a woman and a mom, I understand how difficult it is to navigate careers and family life. So I was the head of an office, and it presents challenges when you have people who are out with their kids or at appointments or on maternity leave. And I was that person. So I appreciate that somebody has to cover all the work when they're out. However, if you make it mom and dad in the office, a welcome policy that everybody gets to go to their kids' concerts or their kids' doctor's appointments, then people will help out each other and not have the expectation that this is only going to be the problem of women and then all the men are going to be burdened by it. So I think even in the courtroom, I had an attorney who was very pregnant, and she said the other day, I'm going to try to do virtual when I'm out, and I said, why? You can figure it out. You don't, have a week-old baby and you're on a Teams appearance because you feel like you can't adjourn your case for a week. So I'm like, conference anything with my law clerk that you need to, but do not feel obligated on my account to come here virtually a week after you have a baby, because that's just unnecessary. I think we need to create a world where it's realistic that we have other obligations. Our professional lives are extremely important, and we really care about what we do and the people that we do it for, but we have to balance that. And if you create this expectation that it's not just women who bear this burden and it's men who can be out on leave and have these same responsibilities, it'll become more normalized. And I think that will kind of take away the pressure for women to always feel like, when I was pregnant, it was people I think they thought I lost my mind. And so I didn't, all of a sudden, I didn't know how to do my work. And it's like, do you want me to do that for you? It's like, why exactly? I can walk, I can function, I still eat the same way. But it's just, and then you have kids and it's like, well, you can't do that. And it's like, yeah, I can. I do it with all 6 of my children now. So, I think that we need to have this expectation that it's not just women who have these responsibilities and these challenges. And then once it's normalized, then we'll start to become, I hope, more equal.
I think the other thing, and I agree with what both of them have said, the programs that you've put together in part for the Equal Justice and the Courts Initiative are really important. And one of the things, even from my perspective, is I had never read the Judicial Friends Report, which is one of the attachments. And this is going to be a negative note, not a positive note, but I did not know, and I'm sad to say, I did not know that the Supreme Court judges outside of New York City, that 91% of them are white, right? Like that is a huge number, and we're talking about a huge area. And I just sit there and say, well, where is, where can there a difference be made? And I think that also goes to, that's not just a judiciary question, right? Like, people are putting themselves out there, but that's a political question, right? That's also that those who run the parties, right? They have to now make an effort. And then I also want to say to the young people in this room, you can't become complacent, right? Like you can't sit here and expect that you'll see this panel in the future. Because when I look behind me, where are the young people, right? Like you do have to step up. And I'm excited that, in the fourth JD, there are, now there's six women on the bench. But I think that if we start to take things for granted, because I've seen young women when I was in city court, I had, it was a city court trial, a female judge, a female public defender, a female prosecutor, and those two young lawyers, after the whole thing was over, we came back to my chambers and I said, do you understand how unusual this was? Right? I never tried a case against a woman. Occasionally I saw a judge at the city court level, but I never saw a judge on the county level. I never saw a female judge in my district, on the Supreme Court level. And I certainly haven't seen any of color. And that's a problem. And I think we all need to take steps, what we can within our roles, to make a difference.
I guess I will add, programs are wonderful and great, we sat through so many programs and, learned a lot, but I want to just take it back to, can we just have a simple conversation about what we're seeing and point out things that are not right? Particularly from a judge perspective, if I see one of my judges acting or saying something, I'm pulling you aside and like, hey, did you know that was sexist? Did you know that was racist? Did you know that can come off this way? And I'm in a position where I have a comfortable relationship with my other judges where I can go to them and say, and they'll look at me like, wow, I didn't see it that way. It's not offensive. It's not derogatory. I just want us to be better. And I think if we all sort of took that approach and not let things slide and not be silent about the things that we're seeing that are not right, I think we're going to get to a better place. We don't necessarily need a program. I mean, maybe we do, some of us, but I think I've had enough programs. I want to do the work now. I want to make sure that I'm implementing the things that I've learned. And I want to make sure that the people, the students here that are coming after me, they don't walk into an environment that we've had to face or people before us. It should be getting better. And we're moving slow. And so until we start calling out things that are not right in a respectful way, in a way where the person can learn something from you and that we can put our egos aside and be like, okay, let me step back. Whoa, that was wrong. And even I'm not right all the time either, and I can still learn. But if we take that approach, I think we're going to be in a much, much better place sooner rather than later.
Thank you. Great. Thank you, everyone. Welcome back. Thanks for bearing with us with the technical difficulties. I'm just going to ask the panelists that are appearing virtually to mute unless they're talking, just to make sure we don't hear any other private conversation. So our panel is larger, but it's obviously not in person because of distance and other time commitments. Judge Hanlon is appearing from Chautauqua County. Judge Frye is appearing from Texas. Judge Mudryk and Kolakowski are both appearing from California. So I was fortunate enough to have all the speakers that I reached out to agree to participate in the program. Obviously, Judge Ryba is here in person. Due to the distance, like I said, most of them are appearing virtually. These are 4 pioneering women with impressive biographies, and I certainly encourage you to read them all in their entirety. Their stories are amazing. I will just give you brief highlights from their bios. The Honorable Judge Ryba was elected in 2015 by the people in the 3rd Judicial District to serve as Justice of the Supreme Court of New York. Prior to beginning her term in 2016, she held various positions in the court system for the Office of Court Administration and in the New York State Supreme Court Appellate Division, 3rd Department, including Special Projects Counsel to the Deputy Chief Administrative Judge for Courts outside New York City and Special Projects Counsel to the Presiding Justice of the Appellate Division, 3rd Department. Prior to her work with the judiciary, Judge Ryba was an associate at Nixon Peabody. She also served as an Assistant Attorney General for the State of New York Litigation Bureau. Additionally, public service includes appointments first as General Counsel and then as Deputy Director for the City of Albany Community Development Agency. She began her career in public service with the City of Albany Corporation Counsel's office. Judge Ryba is Secretary of the Association of Justices of the Supreme Court of the State of New York, board member of the National Association of Women Judges, New York chapter, past president of the Albany County Bar Foundation, past president of the Albany County Bar Association, member of Judicial Friends Association, member of the American Bar Association, and a trustee of Albany Law School, where she chairs the Law Committee and is a member of the Executive Committee. Judge Hanlon is currently the first openly gay Supreme Court judge in the 8th Judicial District. She graduated from Pace University and was soon after employed at Poisson and Nichols. She has experience both prosecuting and defending cases, having worked both as an assistant district attorney for the Chautauqua District Attorney's Office, as well as the assistant public defender in the Chautauqua PD's office. When she started working at the DA's office in 1992, she was the only woman in the office. She later was a partner at Fessender, Lalmer, and D'Angelo between 1995 and 2005. and later became principal law clerk to Chautauqua County Court Judge Foley in January 2015. She was elected to Supreme Court in January 2022. Judge Hanlon's professional accomplishments include being the recipient of the 2015 Outstanding Woman in the Law Award by the HJD Gender and Racial Fairness Committee. She's very involved in establishing equity in the courtroom through her current roles as a member of the Richard C. Failure LGBTQ Commission, as well as the HJD Gender and Racial Fairness Committee. Judge Victoria Kolakowski became the first openly transgender trial court judge of general jurisdiction when she was elected in Alameda County, California in 2010. She's passionate about ensuring access to justice and is the California Council for Churches appointee to the California Access to Justice Commission. She also serves on the Judicial Council of California's Advisory Committee on Providing Access and Fairness. Judge Kolakowski is a former president of the International Association of LGBTQ+ Judges, 2015 to 2017, and she has spoken widely nationally and internationally on LGBTQ issues, especially transgender legal issues, often as part of the U.S. State Department's speaker program. She's an adjunct professor at the University of San Francisco School of Law, and most recently published The Role of Religious Objections to Transgender and Non-Binary Inclusion and Equality and/or Gender Protection in the ABA's Human Rights Magazine. I believe that is also in your materials. Judge Andi Mudryk. Governor Gavin Newsom appointed Andi Mudryk as a judge to the Sacramento County Superior Court on March 25th, 2022. Before the appointment, Judge Mudryk served as a chief deputy director at the California Department of Rehabilitation, or DOR, which provides services and advocacy resulting in employment, independent living, and equality for individuals with disabilities. She joined DOR in 2018 as a chief counsel and was appointed as chief deputy director in 2020. She graduated with honors in 1989 from the George Washington University Law School in Washington, D.C., and has extensive experience serving leadership roles in nonprofit organizations and in litigating a variety of discrimination and disability-related claims. She is admitted to practice law in California, Arizona, and Michigan. Before joining the DOR, Judge Mudryk served as a deputy director of Disability Rights California, the largest disability rights law firm in the country and the largest legal services provider in California. On a personal note, Judge Mudryk is a proud transgender woman with osteogenesis imperfecta, OI, also known as a brittle bone disorder. Judge Mudryk is the first openly transgender judge appointed by governor in the country and the second openly transgender judge to sit on the bench in California. Last, but certainly not least, and I am so honored that she is joining us even remotely. I want to introduce you to Judge Phyllis Frye, and I'm going to again just do snippets of her biography, but it is fascinating, and I do encourage you to read it. Phyllis Frye is an Eagle Scout, a former member of the Texas A&M Corps of Cadets, a veteran, an engineer, an attorney, a father, a grandmother, and a lesbian widow. She is also the first out transgender judge in the nation, appointed by then Mayor Anise Parker. Currently, her biography is available, and I am blessed with a copy by her very good friend Sharon on Amazon and Barnes & Noble. Now, having lived over 60% of her life as a woman, she always felt herself to be. Phyllis remains on the cutting edge of LGBTQ+ community and especially transgender legal and political issues. When the gay community was still ignoring or marginalizing the transgender community in the early 1990s, Phyllis began the national transgender legal and political movement. Thus, she is known as being its grandmother. With the 6th annual transgender law conferences and the grassroots training of future transgender activists, lawyers, and bloggers. Judge Frye is one of the task force's 1995 Creator of Change Award winners. In 1999, she was given the International Foundation of Gender Education's Virginia Prince Lifetime Achievement Award. In 2001, she was given the National LGBT Bar Association AKA Lavender Law's highest honor, the Dan Bradley Award. She has also received the Civil Rights Leader recognition from the Southwest region of the Anti-Defamation League. In 2022, she was given the Diversity and Inclusion Award from the University of Houston Law Alumni Association. She is 74. Trish, her wife of 48 years, passed in 2020. She is retired from law practice in August of 2021 and from her judgeship in December 2022. But is no less active in her pursuit of justice, as you can see by her presence here. Thank you so much for being here with us. All right, so I would like to start by asking each of you to tell us a little bit about the journey and experience as a first on the bench and discuss if you are seeing any differences in how litigants, staff, attorneys, peer judges see you or treat you as compared to your male colleagues. Yeah, I'm gonna just direct a little bit that Judge Ryba start first.
First of all, I'm honored to be on this panel with so many trailblazing women, so thank you for including me. My journey to the bench involves a whole lot of resilience. It also involved visualizing my goals and making a succinct plan to achieve them. I had mentors who helped me select positions in the legal field, so that way when an opportunity arose to run for judicial office, I would be ready. Initially, I thought I would run for Albany City Court, but after I went on an interview for an open position for the Supreme Court before the party in 2014, the feedback was that while I wasn't the selected candidate, at that time I had impressed many members and I should come back. So the following year, when an opening resulted from Judge Stein's appointment to the Court of Appeals, I went on the interview again and was selected this time to be the candidate in Albany County. The next hurdle was to get the chairs. Now, when I was selected in Albany, that was the first time it had ever happened in the history of New York State. So as some of you know, the 3rd Judicial District, where I was elected, is made up of 7 counties. It has a population of approximately 867,000 people, of which about 85% are white and half are men. So as I endeavored to get the endorsement, there was some doubt in my mind that I could be elected. Why, you might ask? Because before I ran, no person of color had been selected to run as a candidate for Supreme Court in the entire 3rd Department, which makes up 28 counties. So I had to go inward and focus on why I wanted to become a judge and make sure I spoke from the heart when I visited constituents in the 7 counties that make up the district. There were some people initially who were on my campaign that didn't think I could win because they hadn't seen it done before. Needless to say, they were phased out of my campaign team. It really became important for me to only surround myself with people who knew my qualifications and wanted me to succeed. I also focused on others who were the first. I thought about how there was a Black president at the time. I looked at people who had already achieved becoming a judge, like Judge Treese, the first magistrate of color in the Northern District of New York, as well as Helen Heath, who at the time was the first judge of color elected to the city court in Albany. Those people inspired me. I also kept reminding myself of why I wanted to become a judge. And the reason why, and it still is to help people resolve their problems. I reminded myself that I have always competed as well as collaborated with people from different backgrounds. So as I endeavored to run for the position of New York State Supreme Court Justice, I felt my template of past experiences had prepared me. You all heard my bio from our moderator, so I won't go over it again, but I felt ready. Little did I know I was about to go on a roller coaster ride. Of course, I was thrilled when I received so much support from fellow alumni, mentors, colleagues, and friends, some of whom are here today. But while I had ample support, I also had people who were conspiring to see me fail and attempted to derail me. Nonetheless, I stayed focused, kept my eye on the prize, and kept moving forward. I am a strong believer in what doesn't kill you makes you stronger. Indeed, I wasn't appointed to the position of Supreme Court Justice, nor did I run in a year where the swing vote was irrelevant due to a large turnout. I was elected by the people in the 3rd Judicial District in a highly competitive voter-dependent year, by a population that mostly does not look like me, but still chose me. As a result, today, I am proud to serve the people of the state of New York as an elected Supreme Court judge for the last 7 years. And now I have the freedom that only comes when you follow your dreams, you stay focused on the future, you learn from the past, and keep your eye on the prize. That's the freedom to be the best judge that I can be and to provide justice for everyone.
Thank you so much. Thank you for that. That was inspiring. So I think we're gonna move in, let's say, geographical order. Judge Hanlon.
Good morning. As was mentioned in my bio, I live in Chautauqua County, which is a very red county. And when I started in the DA's office in 1992, I was the only woman lawyer. And then subsequently in 1998, when I joined the public defender's office, I was the first woman ever hired by the public defender's office. And I was also gay, but I worked for Republicans. And in the 90s and the 2000s, if I had been out, I would have gotten fired quite quickly. So it was a hard time because you have to listen to people speak about my community, the LGBTQ community, in a negative light. I remember when Governor Cuomo and the legislature was first discussing legalizing gay marriage, and the lunch table at the DA's office where I was working, there were a group of people that were speaking about how horrible it would be to pass gay marriage legislation. And they also said that, you know, they don't, and the local legislature was passing a recommendation that it never happened, not that it had any legal effect. But in that discussion, you know, they also said, well, we're lucky because we live in a Republican county, so there aren't any gay people here. I dissuaded them from that belief. But it was tricky navigating that. And then fast forward, I ran for the first time in 2016, the year of the president whose name I won't speak, who won, and I lost by less than 1%. And I had a lot of people during that time that I was running say, Grace, don't, why do you have to tell people you're gay? You're qualified. And, you know, trying to convince them that it was important that I say both because of my history. I think, you know, if there's any young people there, I think the work that I do with the Appellate Commission and other things, what's most important to me is that young people that want to be professionals or whatever they want to do, that they never have to experience what my generation experienced, which is outward discrimination, not being able to talk about your family or your spouse for fear of getting fired. I want people to be respected for their qualifications and what they bring to the table. You know, I'm very blessed to have been elected a Supreme Court judge. So thank you very much.
I think we'll start with Judge Frye moving westward.
Okay, well, I'm Phyllis Frye and I'm not 74 anymore. I'm 75.
Sorry.
That's okay. I live in a retirement community. As you know, I retired from practice of law after 41 years, and I retired from being a judge after 12 years. But during all that time, I was very active as a transgender advocate. I sat in a municipal court, which is traffic court. Very few defense attorneys ever showed up. By that time in 2010, when I was sworn in, I was very, very well known in Houston, Harris County, and in a lot of Texas. So me being transgender was just not an issue by then. Of course, it was an issue way before then and caused me to lose my military career and caused me to be blackballed from engineering, which is why I ended up going to law school. And my wife, Trish, after 3 years, she said, "You've got to be who you are." And so I became Phyllis, and she stayed with me all of those years. And this is my story. The book is dedicated to her. And my friend, Sharon Stewart, Sharon, raise your hand out there. Sharon Stewart is in the index because she was there for a lot of the stuff in the 1990s and the 2000s. Before, in 2008, we got the Human Rights Commission to finally accept trans as being inclusive in the lesbian, gay, bisexual, as it was known then, community. I've had a very fun life. It was a hard life. There were a lot of tears. There was a lot of hardship, but there's nothing like being who you truly are. And I'm very happy about being who I truly am. Now, Grace just talked about when she was trying to get work. Well, I went through that period a long time. I became a lawyer in 81, and I never really got meaningful work until around 87. And that was when I started going to judges that I knew because I had screened them. Our judges run for political office. I had screened them with the Gay Caucus, and so they knew who I was. And I went to them and asked them for appointments to the bench to represent indigent criminal defendants. And I became very good at it. Now, even though I can't speak about bias on the bench because I really didn't experience it as a trial attorney, I will tell you that I used the fact that I was transgender to my advantage every time we would voir dire a jury. In Texas, we call it voir dire. Y'all call it voir dire. But as I would go through the panel, I would always out myself as being trans and educate them on me being trans and ask them if that was going to cause them to have a problem listening to the evidence representing my criminally accused defendant. And there would always be quite a few of them who, for religious or political reasons, would say, yes, we had a problem. Well, guess what? That's a strike for cause. I didn't have to use a peremptory on any of those people, and they were all very conservative, and they were going to vote against my client no matter what the evidence was. As a lawyer representing trans people, and I took several hundreds of trans people through the courts to get their names changed, their gender ID changed, and their sex changed on their birth certificate. I use the state rules and the local rules because there is no defending attorney. It's just me and my client and the court. And so using the venue laws, I would bring clients from all over the state into my county because I would move for change of venue. There was no opposing counsel, so that was automatic. And then when I filed in my county, if I got a bad judge that I knew was going to be a bad judge, I would use the local rules, which said that if you're doing something uncontested, like a name change or something like that, you can go to any court in the county. Well, I had about 6 or 8 friendly judges in the county. So I always took my clients to a friendly county and a friendly judge using the local rules. So if you're trans, use it to your advantage. I could go on for hours and I won't. I invite you to Google my name. Just Google my name and you will see the 2015 article where the New York Times put me on the front page of a Sunday edition. It was a very positive article. And if you scroll down, you'll see videos of lectures that I've given around the country over the years. And finally, if you as a spouse or loved one or friend want to know how to be an ally to a transgender person, I encourage you to Google Trish, T-R-I-S-H, Trish Frye Legacy, because it was her story written by the Houston Chronicle about our life together, and you can learn how to be an ally. So I'll let the other judges talk.
Everything is tissues, and I feel like we're getting emotional. I'm just getting emotional listening to your story. I'm gonna move on to Judge Kolakowski. And you're still muted.
Technically, Sacramento is east of Alameda County, so I think that
Who is
Judge
going?
Mudryk should go from first.
Logically now, I believe that
All right, well, I would defer to my wonderful friend, Judge Kolakowski, but I'll go ahead. Hard to follow these amazing women. I am 59. I think we're disclosing our ages for some reason. And I came out as a gay man when I was 19. And I only transitioned my gender, started transitioning my gender when I was 54, so 5 years ago. So I've had a long career, and just listening to Judge Hanlon tell the story of, practicing in the early 90s really resonated with me, of starting out and not being out. I remember in the early 90s when President Clinton was in office, and there was much talk before gay marriage about don't ask, don't tell, about bans in the military, and not being out and hearing my male colleagues talk about fags in the military and how awful it would be, and having same-gendered military members having to shower with those gay people. And I also remember graduated from law school, really early on listening to a speech from the legal director at Lambda Legal talking about gay marriage. And that was the first time I had heard about it. And I honestly thought, what a ridiculous concept, because we have no rights. We can be fired from our jobs. We can be denied housing. And I thought, why are we talking about that issue when there's so many basic human rights that we don't have? And I could go on and on, but in retrospect, brilliant move, right? Because that was the heart of the issue, and I was wrong. So in any event, I had a long career. I had a prominent role here in Sacramento. I was out as a gay man, married to my husband for 25 years. We raised a beautiful son who's now 23, and I always have known that I'm female, and what Judge Frye said resonated with me in terms of never feeling like I quite fit into the gay community. But I at some point when I was 54, I just started contemplating my life. My son was graduating from high school. I was unhappy in my marriage, and I just decided, if I don't come out now as transgender, I never will, and no one will really know who I am. And I don't want to die without revealing my true self. So I started transitioning, and I was terrified that I was going to lose my job. I was a chief counsel at a state department with 2,000 employees. I worked for the state of California. Those of you not in California, I know you think that, because I'm not from California, I'm from Michigan, you think California is this liberal bastion where everyone is welcome. And the truth is, some of it is, and some of it's not. And I was terrified that I was going to lose my job. There are 300,000, about 300,000 state employees. I didn't know one other transgender state employee. And so I was terrified. Anyway, I didn't lose my job. The leadership was very supportive, but what I also found was that bias, which I've known throughout my life, bias often isn't explicit, and discrimination often isn't explicit, and things happen to you and you don't quite know why. So anyway, I could talk for hours. I think that I was appointed as a judge just less than a year ago by our wonderful governor, who has made incredible attempts to diversify our bench. I know Judge Kolakowski is going to talk. She was elected in 2010 when it would have been impossible for a governor to appoint a transgender judge, and probably a gay or lesbian or bisexual judge. I think what's interesting for me, I transitioned. It was very public that I'm transgender. I also have a significant disability that doesn't seem to be as sexy as me being transgender, but that's been my life's work, disability, right? So and I'm one of few judges who have a significant disability. Anyway, when I got to the bench, I had already transitioned, and to me, there's some interesting treatment, ostensibly being really welcome into the community, and then some, what I think is implicit bias. I have a long history of litigation. I was a legal director at the largest disability rights law firm in the country, and I got here and folks tell me like there's this trope going around that I have no litigation experience. And I wonder, is that denying me opportunities? And is that really because I'm trans? Is it because I'm a woman? Is it because I have a disability? I don't know. I guess that I'll close with, I think I feel really privileged to be who I am, not just because it's great to be who I am, but also to see the disparate treatment that women get versus men. And I think, people talk over me all the time now when I didn't notice that now. And even from the bench, litigants, male litigants, members of the staff talk over me, and it's just fascinating. So anyway, I know I'm rambling, so I'm going to turn it over to my dear friend, Victoria Kolakowski.
Thank you. I'm Vicki Kolakowski. I'm in Oakland, California, right at the moment. This Alameda County, we're right across the bay from San Francisco. And I actually have New York ties. I grew up in, I was born in Queens, grew up in Brooklyn, went to high school in Manhattan, my parents moved to Staten Island just before I went to college. I spent one summer over in Troy on a National Science Foundation fellowship over at RPI. So I spent a little bit of time in the Albany area, lovely up there. And I wish I could have been out there and been with you guys in person, but that was not to be this time. And so I hear the stories. We have 3 transgender judges here who have very different and very similar experiences in a lot of ways. For me, I transitioned. Well, I mean, I knew all my entire life I was trans. I came out to my parents when I was 17. I was in college, and that went okay. I went through therapy. I was getting ready to transition. I fell in love with a woman. It never occurred to me that I could be a woman and be in love with one. And so I tried to be a straight guy. That didn't really work. I got married to somebody who later came out as a lesbian, and then later came out as being non-binary. And so now I'm the boring gender conforming one, and my ex is the wild transgressive one. But I went to law. in law school at Louisiana State University in Baton Rouge. My ex was a year behind me, and my last semester in law school, I came out. That was an experience. Now, what I will say is, if you want to see more talking about me, don't go to Google, go to YouTube and put in my name. And there are a number of videos of me, either me talking about things or local news coverage, or you can just send me an email. If you send me an email, I'll send you a link to my YouTube list of all the videos of anyway. So it was quite uncomfortable. We had problems with the law school. They wouldn't let me use the restroom. I couldn't use the men's room, the ladies' room. I got to cheat to the dean's private bathroom. They made me graduate as a guy. I had my best grades in law school that semester. Because I wasn't hiding anything. I applied to take the bar exam in Louisiana. I was denied because they said I wasn't of sound mind because I was trans. I had to appeal that to the state Supreme Court. That was my first victory, was before I got to take the bar exam. And I did not really feel like using my brief as a writing sample because I really didn't want to come out to people that way. But people found out about me. This was before the internet, but somehow word spread. And so when I looked for jobs around the country, and I had a hard time getting positions because I would go in, I'd interview, everything be fine. I'd call, this happened honestly at least a half dozen times. I'd call the hiring partner and say, I ask what's going on, and they would say, I've been sitting here trying to figure out how to write the letter. We just don't think you'd be a good fit. And that was almost inevitably because because they talked to people at the school or places I worked, and I was outed. When I finally got a job I was a patent attorney. Unlike these great civil rights leaders that I'm here with, I was boring patent attorney at first. And so I did my work in the community in the political realm and in the nonprofit realm. But as a lawyer, I was just, I was a patent attorney. And so, which is a small and very insular community back then, still is to some extent. And so I couldn't get a job until somebody hired me on the spot. I came out here to San Francisco, interviewed for a job, got hired on the spot, and eventually got outed to them. And I had a headhunter. I know that I was being discriminated because I was trans, because I had a headhunter came to me and said, who knew I was trans, and I said, she said, there's this firm, you'd be a great fit. I said, they're not going to hire me because I'm trans. I know that. And they're like, she's like, oh no, that they're not like that. And she called back 2 or 3 days later saying, oh my God, Vic, you're right. I talked to the leader of the group, and he said one of the partners would quit if they hired me. Now, I honestly do not believe that he really would have quit, but that was the way it was. And so as a solo, I ghosted for other people. I eventually got, in-house jobs, went to work for the state of California. I was eventually became an energy regulatory attorney for the state of California, became an administrative law judge, first at the Department of Insurance and then at the California Public Utilities Commission, then ran for a seat because I was approached about running for judge in San Francisco, because you don't have to live in the county that you represent here in California. And I said, no, I'm not going to run against an incumbent in San Francisco. I will run, however, in Alameda County, where I live, for an open seat. And I did, and I got stomped. And I ran again, and the next time I won. And and so what I will say is that California people don't like to be overtly discriminatory, but that doesn't mean that they're not. And I think that what I'm gonna call, I'm sorry, I just want to say Andi, because I know Andi, and I've known Phyllis since I went to the International Conference on Transgender Law and Employment Policy in Houston back in the 90s. And I've been talking to Andi before she got on the bench. And so I know we're kind of a small group. There's only like 5 or 6 trans judges around. So we kind of know each other. But but I think that I think it affects assignments. I think it affects how we're perceived by people, and it's very subtle. And one thing that I know I was talking to my clerk about a week ago, and she told me that we had this visiting. We have a part-time court attendant who's with me certain days of the week, and my clerk said to me, we were talking about whether or not everybody, I said, everybody knows who I am, and, a question about whether I pass. And she said, oh yeah, he said, the court attendant said that he was talking to somebody else, and they said, who you're working with? And I said, Judge Kolakowski. And they said, oh, the transgender judge. And he said, I don't think so. And so I came out. But the thing about it is, I'm the transgender judge. That's how they talk about me. That's how I'm identified to people. That's the image that people have of me. I don't know whether that's a good thing or a bad thing for people, but it's a thing. They don't talk about me based upon my abilities, my experience, or anything else, or that I have red hair. I have the brightest hair of any of the judges. No, I'm not the redhead. I'm not any of that. I'm the transgender judge. And so, and that's what I'm going to always be. I'm going to always be the transgender judge. But, and I've gotten like all these awards for being a trailblazer, but the truth of the matter is that I've just been myself, and I've been too dumb to give up. And so I just keep butting my head against walls until eventually I persevere. And like Phyllis, I was surrounded by people who loved me and supported me. And I think that that was really important for me on my journey.
Thank you so much for that honest story. I'm gonna switch gears a little bit, and we were talking earlier about how seeing representation on the bench may impact the public's confidence in the judicial system. And we mentioned this in the beginning of the program when our virtual panelists were not here. There are a number of articles in the CLE materials that discuss bias in the context of the LGBTQ community, which are truly opening. So I would suggest that you read those. For all the judges, do you believe that your experience in being a woman or a person of color or gay or transgender judge helps you appreciate the more nuanced aspects of litigants or an attorney's case? I'm going to go in the same order that we did before, which Judge Ryba, and I'm going to ask our speakers to mute themselves if they're not talking, just so that we don't catch any private conversation.
So can you please repeat the question again?
Yeah, absolutely. So do you believe that your experience as a woman or a person of color or gay or transgender judge helps you appreciate the more nuanced aspects of a litigant's case or an attorney's case?
I do. I mean, I think that we all bring our backgrounds to the bench. So as a judge of color, as a woman, I can, and as you heard earlier with Judge Frost and Judge Brooks-Morton, you can see somebody and have a background that helps you understand where they're coming from. For example, there are stereotypes that Black women are angry. So if a judge doesn't have an experience with people of color, they may think that somebody who's animated or somebody who is speaking loudly is being disrespectful. But because I have people in my family who scream when they're just talking to them, it's not something to be offended by, but it's just cultural, just the way that people communicate. Sometimes different cultures can be more, or at least from my experience and the people I know that there can be times when you're emotional and you can be loud because you want to make sure the person's listening to you. So because I come from a Black community, I can understand that, and I don't place any bias on that behavior. Also, being a woman, there's a long history in this country, the suffrage movement. We've had a long road to get to where we are today, and there's still a lot to go, a lot of way to go with pay equity and other equity issues. So as a woman, I can look at things from the background of I'm a mom. I know that it's hard to balance things. So I don't judge somebody if they're running a little bit late because they had to drop their kid off and daycare was closed or someone had COVID, because I've experienced it. I have a 14-year-old. I know what it's like when your kid is sick and then has to be 24 hours before they have a fever. So I can understand if I have to adjust or move a conference because of childcare. And now that we've evolved, I also realize that it's not just gender now when it comes to childcare. There are men now who are, home with the kids who need those same accommodations. So I also think my background, my brother is gay, so I have a background of having a gay person in my family. And so I bring that perspective. And so I think it's really important to have diversity on the bench, because without people on the bench that reflect the people in the community, you won't have that side of the viewpoint. So I guess I answered your question. I think I went on a tangent as well.
Thank you, Deb. So we'll move on to Judge Hanlon.
Yeah, just briefly, I think that my experience helps me to be more attuned to implicit or even outward discriminatory or negative comments or things that are not proper, and I have less of a tolerance for it. In this position, I'm more empowered to make sure it doesn't happen, to protect people that are in not a position of power when they're in my courtroom. So I think that it's my sensitivity to people not treating other people well because of who they are. I think it's the biggest thing. Thank you.
Thank you.
I think I'm next. I came out full-time as trans in 1976 and was immediately invited by some very progressive women in Houston to join the local chapter of the League of Women Voters. And I've been involved in the League of Women Voters. I'm still a member of the Houston chapter of the League of Women Voters. And I met some fantastic and dynamic women who taught me exactly how much garbage women had to put up with back then. And I experienced a lot of it myself. I also have a story from the 1980s when I was down at the criminal courthouse in the basement cafeteria. Attorneys would gather before a docket call at the various tables and visit and talk about what their case was going to be. And I found initially that I was very welcome at tables that were predominantly inhabited by people of color. It's not to say there weren't white attorneys who were friendly to me, but there were still a lot of them that were standoffish because I was pretty new about being an out transgender attorney, but not so at the tables inhabited mostly by people of color. And I commented about this one day to one of my lawyer friends. And he said, "Oh, well, that's easy to understand." And I looked at him with question marks all over my face. And he said, "You are judged not by your education, not by your background, not by your ability, but by the way you look. We, as people of color, are judged not by where we went to law school, not by our abilities, not by our anything other than the way we look." And so there's a definite camaraderie between me as a trans person out of the closet and the person of color community initially back in the 80s. And so I became very much of an activist for everybody. And I'm glad for that, especially when you consider that when I was a kid in San Antonio, Texas, my family taught me, and prejudice is taught. My family taught me to discriminate against people of color, people who were different religions, people who were Jewish, people who were different for, just a whole sort of reasons. And it took me until I was in college to finally be able to shuck all of that hatred and discrimination that I had been taught. And I'm very glad about that. So that's my answer.
Thank you, Judge.
So I guess I'm next because I'm east of Judge
Yeah.
Kolakowski. So,
Whatever, I understand it.
and I know we're short on time. Absolutely, representation matters, and on the bench, and it's not because we will rule in favor of people who come from our communities, but it's so that we can create an inclusive environment where everyone is welcome and everyone has confidence in the justice system. So I guess just briefly, one of the things I've done since I've gotten here is I feel an obligation to be out and proud as a disabled person, as a trans person, as a woman, to create an inclusive environment in the courtroom. And so one of the things I do is ensure accessibility for people with disabilities, and including for myself. There's, you might have noticed that the bench is raised, and most benches have steps. And there was all this discussion when I got here about how I'm going to get up the steps. And so in any event, that's a piece of it, just ensuring that folks who have hearing impairments can hear, that folks who have mobility impairments can come in, that folks who have mental health disabilities aren't treated less than. I had one woman who was, I started out overseeing traffic cases, and she had a legitimate traffic issue, and she was having hallucinations while she was in court. And my staff were mumbling about committing her and calling the sheriff in, and they did call the sheriff in. And I just stopped everyone and said, she has an issue and we're going to deal with it, and she's not hurting anyone. So stop, and sheriff, please leave. And okay. And then and now I'm overseeing juvenile justice cases, and I attribute this to pioneers like Judge Frye and Judge Kolakowski and others who, just like the lesbian gay movement, because of their visibility, have created an inclusive environment where people feel welcome. I see kids who are proud and open, being non-binary and transgender, and not receiving the services they need in the juvenile hall, and making sure that we use the correct pronouns and give them the services they need. And then finally, I am also a proud mother of a young Black man who's now 23, and have seen him, and he's 6 feet tall, and he has dreadlocks, and he wears hoodies, and I've seen him be profiled. And I see the young Black men who come before me now, both in traffic court and juvenile justice court, and I know that racial profiling is real. And so it's a piece of what I bring to the bench. So off to Judge Kolakowski.
Thank you.
I agree that we bring all of ourselves, all of our experiences. And I think that representation does matter. I think that it matters for people to see people like themselves on the bench. I think it's important for the community. And in terms of whether or not it makes me changes who well, obviously I'm informed by everything that I've been through. Not just because of that, but not just by being trans or a member of the LGBT community, but also I came from a blue collar working class background, and believe it or not, that's almost as rare among my colleagues as anything. That I understand that when I see people who would come in front of me, and when I was doing misdemeanors, I looked at them. These are the people I used to live next to, or these are the people I grew up with. You know, not literally because I grew up on the other side of the country, but these were exactly the type of people. These were the people that I knew. And I'm not sure that that's true of everybody. And so I think that it's important, and I try to speak plain English to people. I try not to use jargon. I think that in some ways that may hurt me because some people may think that I don't know the fancy legal terms. I do know them. I just don't use them because if I can avoid them, because I want to make sure, especially because I've been, right now I'm in an assignment where I have a lot of either self-represented people or, yeah, a lot of self-represented people. I want to make sure they understand what I'm talking about. And I don't think it's right for us to be, so I understand what it's like for a lot of people because of all the things that I've gone through, all of my experiences in life. And so I'll just leave it at that because I think everybody else has said everything pretty well. I do want to say, I did mention my age, right? Everybody else was telling their age earlier. I did say I was 61, right? Oh, I'm 61. Am I getting applause for being 61? I'm sorry.
All right, so I think I just remembered I did not give the second CLE code for our one panelist that is attending virtually. The first one was bias, and I believe she did not hear that one. The first one was bias. The second one is equity. All right, so I know that we're a little bit over time. I do want to ask, though, to finish on a positive note, as pioneers in the court system, do you feel like sufficient progress is being made towards embracing equity in the court system? What, if anything, do you think could help in this respect? And I hope this is a positive note, but we never know.
Thank you for asking that question. So in your packets, wow, sorry about that. In your package, you'll see the Judicial Friends Report from 2020, and that highlighted a lot of deficiencies that the court system has with regard to judges being appointed to the Court of Claims, people in supervisory position, people in just appointed positions throughout the court system. Since then, and I think Judge Frost alluded to the John Jay report, there was also a report by OCA, and they had similar findings, and they took action to correct them. And so in the last few years, we have seen progress. There have been more people of color appointed to the Court of Claims. There are more people of color and women appointed in supervisory positions. And I believe a few days ago, OCA released a report on some gender numbers that are promising. So there's still a lot of work to be done, but I think we can end on high note because there is progress being made. And so that's exciting to see.
Yes, thank you. Judge Frye.
Well, I'm the wrong person to ask because my state, our judges are elected. And so they have to run in party primaries. And it depends a lot upon what county you're in. I'm blessed that in Harris County, it's all blue right now, but there was a period in the 90s when it was red, and it was very difficult to get, for me, to get appointments to represent indigent clients. And also our governor fills vacancies. And that's all I'm going to say about our governor. But in closing, Sharon Stewart, you're out there. Raise your hand again. Everybody talk to her during the break. Bye.
So I feel like I'm keeping you on your toes because I just skipped and I went out of order. So Judge Hanlon.
Thank you. I am lucky enough to have been appointed to the statewide commission, Richard C. Fella LGBTQ+, which is a New York State commission. And I believe somebody mentioned earlier that Judge Elizabeth Gary is there, and Judge Gary and Judge Khan were the original co-chairs and the pioneers in this commission that works to and has worked to fight, discrimination rules and policies within OCA, and also a lot of education. And I think for me, that's one of the most important things that the Fella Commission does. And just as a short story here locally, last year there was a young attorney that was transitioning and had been practicing here as a male and was transitioning to a female. And she called me and said, I'm afraid that I'm okay in my job, my boss is okay, but I'm afraid I'm going to be treated poorly by judges, that they're going to make it impossible for me to practice. And I was lucky enough that I called Matt Skinner, who's the executive director of the Fella Commission, a wonderful guy. And we quickly set up a Teams seminar for all the judges here in this county, specifically for this woman, so that she could feel comfortable and they would be educated about transgender before she fully transitioned. And it was very impactful. We had that almost a year ago, and this transgender local attorney has said she's had mostly positive experiences in front of the local judges. So thank you.
I guess my turn, just really briefly. I think that being present and vocal and out matters. I'm kind of an introvert and uncomfortable talking about myself. And I never turn down a request to speak because I feel an incredible obligation to be who I am and to let folks know. And none of the things that we're talking about would happen if we didn't have a seat at the table. So we need to have seats at the table. And for those of you who are listening, you need to put yourself forward, even if you have imposter syndrome and you think you're not qualified and you can't do it. We need to be in positions of leadership for things to change, and we need to be seen. Thank you.
Judge Kolakowski.
Okay, I'm going to start off with the cutesy answer and then I'm going to elaborate it. That is going to be, we're obviously, since we're pretty much close now to eliminating sexism, racism, homophobia, transphobia, ableism, and all these other things that are affecting society, clearly we're almost past all this. But I point that's my sort of cutesy answer. But the truth is, look at how we've made progress in many of those areas. I was talking yesterday with my mother, and she was telling me, reminded me again of a story that about the time when I was in elementary school, and she was in one of our teachers actually showed her how she could buy an encyclopedia for us as kids, signing for it herself without my father's signature. In my lifetime, this was like a radical thing that she could actually sign a commitment legally in her own name. And so more recently, we have gay marriage. We have a lot of different things that we've moved forward on. You have trans people on a panel that are judges, speaking to an audience of lawyers, sponsored by a law school, and by bar associations. And so, while it can sometimes seem daunting, the task that's in front of us, because every generation has to face this as we try to improve ourselves, we have made a lot of progress. And I think that we will continue to make progress. And that's as long as all of us who care about these issues and care about eliminating these biases that I just talked about earlier, as long as we continue to be vocal and be active, and as long as organizations like this continue to provide education and programming like this, I think that we have a bright future.